So because I was getting super cheeky this week, I'm going to switch. I decided, I decided to send an email to the Crown's office because I was in court this morning and I sent an email to the Crown's office. And I wrote to the Crown's office on Monday night, I think it was, to all parties. The rules set out in the Provincial Offences Act. Now I'm starting with the Provincial Offences Act because we're operating under the Provincial Offences Act. I wanted to see where they were going to go with this. The rules set out in the Provincial Offences Act are the rules that govern 1, the court, and 2, the Crown, and 3, the officer acting as the state agent. The defendants cannot find any rule that requires the defendants to ask leave. So remember I told you we have to ask, they're saying we have to have the judicial authorization. So to have the judicial authorization means we have to ask for their permission. That is known in court as asking leave. So we cannot find any rule that requires the defendants to ask any leave of the court to record their hearing for their personal records. All parties have until 6 p.m. on August the 10th, 2022 to provide the rule under the jurisdiction of the Provincial Offences Act that requires the defendants to request a hearing, to request leave of the court to record their own hearing. And then I just wrote, in absence of any evidence of any rule under the Provincial Offences Act being provided, the defendants will not bring this matter up again and will pursue their lawful right to record as set out under the provincial offense, under the provisions of the Constitution Act of 1867 and the defendants declared, recognized, and protected human rights and fundamental freedoms with the Canadian Bill of Rights 1960. Thank you very much. Amanda Ridding, acting on behalf of the defendants with their consent. So then I get this response in the morning. Good morning. Per Section 136 of the Courts of Justice Act, it is an offense and may constitute a contempt of court. So they're pursuing even the court in the city of Barrie is pursuing the same law as the court in the city of North Bay. And the sooner we get this information out, the sooner we can call them out and get them to stop the baloney. They need to stop committing fraud. They need to stop deceiving the people. So it says, so they go on to say to record, photograph, publish, or broadcast a court proceeding in any way unless prior judicial authorization has been granted. I have copied, so they're doing something really nice. They've copied a section below and provided the link to the statute for the ease of my reference. And then it goes on to say prohibition, and it reads exactly what I just read to you. Section 130, Rule 136, subsection 1 is subject to Section 2 and 3, and no person shall take or attempt to take a photograph, yada, yada, yada. You can't do it at a court hearing. And we already know the conflict between what is said, posted on the North Bay courthouse doors and what this actually says here. Okay, so they repeat the whole thing and then they give me the link. Isn't that kind of them? And I, of course, was feeling cheeky. Now, did I download it? Give me a second. Oh, yes, I did. Let me just open the remainder of the photos because I did download the rest of these. So again, feeling super duper cheeky, and just because I am fed up with these people committing fraud and trying to misconstrue and misdirect us on how the law is meant to be applied. And if they're telling you they need to interpret the law, then object. Okay, it's English. It doesn't need interpretation. It's meant to be applied the way it's read and written. It's English. The definition of interpret is to change something. If you're interpreting French to English, you're changing the language. So if they have to say they have to interpret the law, then they're changing the language. Don't let them change the language. Tell them to stop it. So going back, I responded to them twice. The first response, I said, good morning. I am reviewing the rule you sent me. Where does the rule say I require judicial authorization? Remember, they told us I had to have judicial authorization. Remember, they told me that. Remember, the North Bay told me I had to have judicial authorization. So I said, where in this rule does it say I require judicial authorization? As I understand it, the rule of law, if the rule does not state I have to ask for leave of the court, aka judicial authorization, then the court does not have the authority to grant any such request. Under Rule 136, in absence of expressed authority first being granted to the judge to issue any authorization to anyone, then under Rule 136, the judge has no authority to grant or authorize any such request by anyone. They don't have the authority to grant it, therefore you don't have to ask it. Say, no, forget it. I have the right to record my own hearing. And as I give me a second. And as I understand the principles of fundamental justice, anyone can record any hearing they are a party to, so long as they are recording for the purpose of supplementing their own notes, which is the sole intent of the defendants. And which means your statement, unless prior judicial authorization has been granted, is false, because no judge can grant authorization where they lack the authority to grant the request. A false statement implies an intent to deceive, which is conduct unbecoming a barrister or solicitor, which means conduct, including in a lawyer's personal or private capacity, that tends to bring discredit upon the legal profession, including, for example, A, committing a criminal act. Remember what deceit is? It's fraud. Committing a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer. B, taking improper advantage of the youth and experience and lack of education, unsophistication, ill health, or unbusinesslike habits of another. Or C, engaging in conduct involving dishonesty or conduct which undermines the administration of justice. Wouldn't you say, folks, that them telling people that they could be thrown into prison with those are threats? Those are threats. You could be fined. You could be thrown into prison. You can't do this. You can't do this. It's prohibited. They misconstrued, misapplied the law, and then they threatened you. Is that not a criminal act? Where does Rule 136 state that the judicial authorization is required? It does not, unless you, in error, left that part out. The law you cited does not appear to grant the court any authority to grant anyone's request to record their own hearing. And then, just for good measure, I said, wherefore, in the absence of authority to grant anyone's request, no one is required to make a request, as the court does not have the authority to grant such a request. Please present the rule that grants authority to the court for the court to authorize any request to record one's own hearing and supplement their notes. We will not make this request before the court if the court does not have the authority to grant the request. It will be as though the request was never before the court. And the defendants do not intend to contravene 136 with respect to irrelevant party publications. So that's my response. Now, bear with me 1 second, because I got even cheekier, and I just have to call it up here, because I ended up sending one more. And I want to read that to you as well. But I have to first just make sure I've got it on my computer before I do. So, because I sent them, after all that, I sent them one more email, because again, they just pissed me off. They pissed me off with their baloney. So let me switch screens, because I think I've got it here now. I think, no, that's not it. Bear with me, and I appreciate your patience. Jiminy Cricket. Nope. Let me close this. I'm just going to close this for a second. I can't, I'm working on a shrunk screen. There we go. I've got it up. So it's a lot harder when I'm working only on my one computer. So I sent them one more email, and I wrote, good afternoon. I would like to add under Rule 136(2)B. So remember, I already showed that rule to you. So I decided to highlight it for them. Nothing prohibits, the judge cannot prohibit a party acting in person from making an audio recording at a court hearing. He cannot prohibit a party acting in person from unobtrusively making an audio recording that the judge has approved the making of an audio recording for the court. Wherefore, if the court/clerk is unobtrusively making an audio recording, it will be presumed the audio recordings are approved by the judge unless expressed otherwise. The judge can only approve the manner, and once approved, under the principles of fundamental justice, it is deemed approved for all. Please advise the parties on the manner of electronic recording that has been approved by the judge. So the moral of the story, I was in court this morning. First off, they did not warn the court about doing audio recordings. That wasn't even brought in. And the justice of the peace herself, the justice of the peace, said to us, "Oh, I understand that you're going to be recording today." And I said, "Yes, we are recording today." And the justice of the peace said, "That's fine. Just so you know, the approved method of recording is audio only. There will be no video recordings today." And I said, "Thank you very much." And then the justice of the peace said, "And just so you know, it is only your own hearing that you're allowed to record." And I said, "Yes, we do understand that. And we also understand that we are not to broadcast or publish any of the recordings, that we're just taking the recordings for our supplemental notes. We will follow the rules." And the justice of the peace said, "Thank you so much." And I said, "Thank you so much." And I won. I won because I know how to read the law. And they didn't tell me I was wrong. On the contrary, they acknowledged I was right. They acknowledged I was right, and they assisted me in ensuring that I knew that audio recordings only were permitted. So folks, start sending your Crown attorneys similar letters if you want. Start challenging them. Start ordering your courthouses to remove that baloney that they've got on their courtroom doors, because that baloney that they've got on the courtroom doors is actually fraud. It is fraud because they are misconstruing and misrepresenting what the law actually says. And the North Bay courthouse is gone over the top because they've taken words and they've attached words to their hearing saying it's prohibited, and it's not prohibited at all. In fact, nothing can prohibit you from recording your own hearing so long as it's for your own records and it's in the manner that's been approved by the court and approved for everyone in the court, because that's called fundamental justice. What they're allowed to do, you're allowed to do, and vice versa. Fundamental justice. All parties are entitled to the same rights. Once something's been established, it's established for all. If you like these videos, please, I hate to say it, like, subscribe, and share. Send them out. We need to get these messages out to Canada, because people in Canada need to start understanding how to read the law. Thank you so much, and God bless.